my name is Mary Perham and I'm a Senior Associate in our UK private client team at Charles Russell Speechley. As part of our new series, The FIC Files on Family Investment Companies, commonly known as FICs, today we explain how succession planning is at the heart of FICs. What should families be considering? We have already touched on trust shareholders in this series. If there's a trust shareholder, it is essential that the trust is reviewed to ensure it is appropriate to hold shares in a FIC, and that the trustees have all the necessary powers. In terms of family succession planning, the first thing to mention is wills. Any family member who has shares in the FIC should ensure that their will appropriately deals with the succession of those. If the FIC has been properly structured and joined-up advice has been taken, the articles will deal with permitted transfers and the wills must be consistent with those. Ideally, the family will have upfront discussions regarding the likely succession of their shares, so this can be addressed early on. For example, if the FIC shares are only designed for bloodline transfers, these should not be left to a spouse on death. If the founder retains shares in the FIC, his or her will be very important, as those shares likely hold voting rights in the FIC, and therefore the founder will want to think carefully about where those go. For example, it may be sensible to leave those to a trust with detailed wishes provided to the trustees. Another important point is powers of attorney. Many shareholders will already have lasting powers of attorney in place to take effect if they were to lose capacity. Those shareholders will need to think about whether their chosen attorney is the right person to be granted authority over the FIC shares. If they are, do they need some guidance around the FIC? And if they're not the right person, that shareholder could consider a standalone lasting power of attorney dealing with the FIC shares only, distinct from their more personal affairs. If a shareholder is due to be married, or perhaps they are married and are about to receive significant shares by way of a gift, they may want to consider pre- or post-nuptial agreements to protect the FIC shares from a breakdown in marriage. On this point, as mentioned previously in this series, some families, particularly where the wealth going into the FIC is significant, take setting up the FIC as an opportunity to create a family charter. This is a topic in itself, but in a family charter, the family can set out their expectations for running the FIC, individuals' involvement, expectations around prudent succession planning, including wills, post-nuptial agreements, through to far more nuanced and bespoke considerations for the family and the intended use of the FIC. Whatever the succession plans of the founder and their family, it's important that these are looked at in the round, and ideally when planning the FIC structure. Poor structuring can lead to tax inefficiencies or shareholder disputes. It is really important when setting up a FIC arrangement that there is joined-up approach between the corporate advisors and the private client team to ensure that there is no disconnect, which could cause issues in the future. Here at Charles Russell Speechlys, our focus on private capital helps us to work together as a seamless team on any FIC transaction. In summary, proactive succession planning and compliance ensures FICs deliver long-term benefits and avoid legal complications. FICs are powerful tools, but only when built on solid foundations. Thank you for watching and look out for future episodes in our FIC Files series.